Hello. Medieval justice was arbitrary and harsh. According to the Anglo-Saxon Chronicle, in 1124, Rafe Bassett, sitting as justice at an assize held at Huncut in Leicestershire, hung 44 thieves in a single day. There was much evidence of the law in action. Gallows were sited at the entrances to towns, at rural crossroads and other prominent places such as hilltops. Corpses hung from gibbets and the body parts of executed criminals put on public display as a warning to potential offenders. But there were various dodges available that could be used by those facing trial to avoid paying the price for their crimes. I talked about compurgation, producing oath helpers to testify to an accused person's innocence and good character in part 5 of this series, and of the availability of individuals prepared to perjure themselves for this purpose for suitable recompense. It was a definite advantage to have financial means of appearing before the justices. In part 4 we looked at the availability of sanctuary, where subject to a confession and agreement to exile, an accused person could avoid trial. And in part 6 I explained how benefit of clergy could be used to have a case switched to a more lenient church court, in certain circumstances even by lay people. One wheeze open to all facing trial for theft was to contest the value of the stolen property. Goods worth more than 12 pence counted as grand larceny, which was a capital offence. For property worth less than 12 pence, the crime was classed as petty larceny, a misdemeanour rather than a felony, for which someone found guilty might escape with a whipping. Juries were often sympathetic to revaluation to preclude the severity of the death penalty. Excuses known as essoins, a word from Old French, could be offered for non-attendance at court to answer a case. These normally had to be offered on the first day of a court session, a bit like giving one's apologies for missing a committee meeting. Acceptable excuses included illness, either becoming ill on the way to court or being too sick to get out of bed to attend. Usually this would require confirmation of the condition by 4 nights. A claim of being overseas would gain a delay, typically 40 days, to allow time for a message to be delivered and for the accused to return. Being on military service or in possession of a letter of protection confirming you were about to go on campaign was also an acceptable excuse, enabling a case to be postponed indefinitely, and in the medieval period there were plenty of conflicts to take part in. If summoned, one could just simply fail to appear. This would result in a warrant being issued to attend the next court session. On the 3 strikes and you're out principle, this ploy could be used up to 3 times. On the basis that, as the phrase has it, justice delayed is justice denied, any delay to a trial was likely to work in favour of a guilty defendant. Circumstances change. Witnesses might die or forget or be intimidated. A change of monarch or a national emergency might bring about a general pardon, a kind of clearing of the decks, marking a new start. When Edward III declared war on France in 1342, the start of what has become known as the 100 Years' War, a general pardon was offered for all homicides and felonies to those prepared to sign up to fight for at least 1 year at their own expense. Royal pardons were also available to those with influence. I came across a case of abduction in the plea rolls where, if the dates are correct, a royal pardon was obtained in advance of the crime being committed. From the late 14th century, and most probably earlier, pregnant women found guilty of a capital offence and facing execution could plead their belly. To qualify, a woman had to be quick with child. That is, the movement of the baby had to be detectable. As with jurors and revaluation, women appointed by the court to check the claim might well be complicit in affirming movement given the penalty faced. If a plea was successful, the woman would be given a reprieve until the baby was born, after which there was a reasonable chance of the sentence being commuted. This defence was only allowed once. The late 14th century is when the popular ballads telling of the legendary outlaw Robin Hood began to circulate widely. Plenty of criminal gangs operated to provide inspiration and role models for the tales. I shall look at some examples next time. If you've enjoyed this video, hit the like and subscribe buttons and click on the notification bell to be informed when the next video is available, or you can subscribe by clicking on the rose window over my shoulder.